planning board is now in session. And before we start, I understand that some people here for the hearing there on the Lake Avenue Estates, Lake Avenue property there with Mr. Hornberger. Is that true? Yes. Okay. There's going to be, I don't know how you got to notice that there's a hearing tonight, but there is no hearing tonight for that application because it hasn't even come back for us there for the rehearing. So I apologize if you're here for the night, but there's no discussion on it. And I think that if you want to leave there, you know, if you want to stay, go ahead, but there's going to be no discussion on that application, okay?
Hopefully it's a message.
Well, again, that's something that's going to come when we have the hearing. But I don't want you to sit all night long here because it's not going to be something on the agenda for it to be heard. The what? No, I think that it,
Could you tell them that, Frank?
it's up to the planning director there. The schedule is there, so.
The next step for the board is to render a decision on this particular matter. There's going to be no more public hearing before this board. However, it's a public matter. You're welcome to come before the hearing and observe the board when they render a decision. When that is done, when this board renders their decision, then that matter is forwarded to the town board, who will also hold a public hearing if they decide to proceed with this application. So what's going to happen is the board has requested certain information from our office. We're still compiling that information. We will give this to the board probably by the next meeting, and then the board will make their minds up as to when they will render a decision. And I'm not sure what you mean by when's the site inspection.
Yeah, we've all done, or anybody that was supposed to do it has done it. I just have not polled anybody on the board to see if they completed the site, inspection. Okay?
Can you be a little bit more specific in dates?
Well, the next meetings that we will have are going to be in September. And what will happen is we will supply the board with information that they requested with regard to, and some analysis from the documents such as the traffic study and other documents that we receive from the applicant. All that information is public. You may come at any time and ask to see the file, as well as the information that we will be given to the board will be public information. Well, assuming we all have it compiled either the first or second meeting in September. If you call my office, I will be happy to tell you if the information is going to be compiled. One of the reasons why I am not able to answer you with any degree of specificness is because the traffic study is sent to our traffic safety department, and I have to wait for them to review it. And I usually get it back within 4 to 6 weeks from the time they receive it. So it could be either the first meeting or second meeting in September.
Right. And when the board gets it, do you have any anticipation how long it will take?
No, I don't have any anticipation there of how the board will act.
No.
Okay?
How long it will take you to make a decision?
The board may ask
Again, it won't happen there until we have that on the agenda to be acted on. That's when we'll make a decision as a board, okay? And you're welcome, if you see it, if you contact the office and the night that we have it there on the agenda, if you want to come, you'll be my guest there, but it's going to be there, just the board is going to act, all right?
Frank, maybe just to avoid this situation in the future, is there any way that you could, since we have no control over what you're doing, maybe you could contact us via an email so that we can...
No, I will tell you this. All the agenda items that this board will consider are decided a week in advance. So by Thursday of the week prior to the meeting, the entire agenda is set. So, well, it is not practical to send an email because then people who don't get the email still come to the meeting. What I would, for anyone who wishes to come, I believe the agendas are probably, we have a little bit of a problem, but they're going to be posted on the web at smithtowninfo.com, but sometimes they've been having problems. But if you call my office on Thursday, the week before the meeting, if you speak to any of the secretaries, they'll be happy to tell you whether the item is scheduled for adjournment or it's scheduled to be heard. And that will be it. And then when this board hears that matter, what they're doing is going to receive the information that we have, which is going to be public, and then the meeting will be closed because the public hearing testimony is closed at the meeting. And then the board will decide which direction they want to go. At previous applications like this, the board has asked the town board, for example, to do an environmental impact statement. And they may forward a recommendation like that. In other words, they may not make a decision. They may do something else. So there's a lot of different avenues that the board may take.
Obviously, we're concerned because we're also busy, like, as you guys are. We don't want this to continue to happen on and on and on.
But we have been receiving phone calls all week, and the secretaries, including myself, and we've been telling everybody it is not scheduled. Okay, I don't know who sent the email around to everybody saying this for tonight, but we must have received at least 20 or 30 phone calls in the last 2 days in my office that basically said, is it being scheduled? And we told everybody it's not. So you're welcome to call my office. Anybody could, it's 360-7540. It's on the agenda. Any of the secretaries will be happy to tell you a week before whether it's scheduled. What that means is if you have an agenda before you, you'll note that there's an asterisk on there. If there's no asterisk on the agenda, that means it's going to be heard. That's the way it is.
Okay? If you want to remain for the Pledge of Allegiance and then leave there, be my guest. The Pledge of Allegiance, please. Jim?
To the flag
Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We thank you. And we apologize, however you got an email.
Really? No.
Would you please go out in the hallway if you want to do any talking? There's plenty of room out there to talk.
So this has to go on and on and on.
No, it does not. What happens, no, you don't understand.
I do.
No, what happens is, we've gone on this road before. If we can't, the town attorney, if we can't send it to everybody, we don't send it to any one person, because then we get accused of notifying certain people and not others. Even if we want to do that, the best way is to contact my office. I'll be happy to answer as many times as people call. It won't bother us. But we've gone down this road before where I personally have notified people, and then the town got accused of not notifying others. We're playing favorites, and we can't do that. All right, okay?
Are we all set now? Please.
Good evening, Mr. Chairman and members of the board. The first item on the agenda, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Part 1, Item 1, number 2011-01, All Seasons Motor Lodge. Item 2, number 2011-10, Anthony Lettieri. Item 3, number 2009-05, FB4 Realty. Item 4, number 2012-02, Carlson Associates. Item 5, number 2012-04, Storybook Homes. Item 6, number 773, Scholar Estates. Item 7, the 288 application of Olivia Estates. Item 8, the letter of interpretation, excuse me, for the Polish National Church. Part 2, Item 9, number 2010-06, KVC Holdings. Item 10, number 1053A Berg Estates. Item 11, number 911A, Glen Hill Northern. Mr. Chairman, these are the items the Planning Department recommends for adjournment.
Is there anybody here to be heard on those applications that are going to be adjourned? Hearing none, a motion.
Mr. Chairman, I'd like to make a motion to adjourn the items read, please.
Second.
All those in favor? Opposed? So ordered.
Mr. Chairman, we'll now move on to Part 3 of the agenda. Item 12, number 919, River Estates. Mr. Chairman, this application was brought before the board at the July 18th Planning Board meeting, at which time it was adjourned pending an on-site inspection by all board members. We understand that your inspection has been complete. We do have a resolution prepared for you if you'd like to have it read onto the record.
All right.
Yes?
Yes, ready.
Okay. The Planning Department offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves the request of Carl Vogelsberg to amend the original conditions of approval in order to construct a 4-foot by 70-foot elevated walkway over tidal wetlands within the subdivision known as River Estates, number 919, subject to the following conditions. 1, a restrictive covenant in a form acceptable to the town attorney shall be filed with the map of River Estates, number 919, in the office of the Suffolk County Clerk, stating that no further placement of structures or the removal of vegetation will be permitted in or near the tidal wetlands. 2, the applicant shall submit copies of all filed documents, including any deeds with meets and bounds descriptions, with a date stamp and file number to the Planning Department. Mr. Chairman, this is the recommendation for River Estates, number 919.
Anyone here representing the applicant?
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I've looked at what the Planning Department has given you as a proposed resolution. One of the things I don't understand is the measurement. It says 4 feet by 70 feet. If that is in any way considered a restriction, then my client has a problem with it, because that only brings us to the high water mark. It doesn't get us to the water. Mr. and Mrs. Vogelsberg live on the water, and by living on the water, you usually would like to get to the water. Now, Frank DeRubius indicates, and I don't doubt him, that in 1985, when the LWRP was originally enacted, this was a limitation that was put in the LWRP, basically because the dock materials that were used were such that they contributed to the contamination of the water. He also tells me today that they have different types of dock materials, some of them artificial, not treated wood, which doesn't contribute to contamination. I have no objection to the resolution, other than the fact that I plan to, and I have spoken to the town board already, with respect to extending the dock from the high water mark to the low water mark so we could get to the water. Otherwise, all of this is for naught. We did, a few years ago, go to the state DEC. They granted us a permit, basically, to get to the low water mark. They don't want us walking over the grass. In the event that this was the only thing that was granted up to the 70 feet, we'd have to get off the dock and walk on the grass, which is exactly what the state DEC doesn't want, because you would be killing sea life and whatever vegetation is there. So if we could just have a modification in your resolution that says you're not precluding us from going further, and that would have to be with the town board with respect to getting permission to go from the high water mark to the low water mark which is what the state gave us a few years ago. And that's our issue. Again, it's really kind of ridiculous if you live on the water, but you can't get to the water and you can't appreciate it. My clients pay taxes, I'm sure commensurate with the fact that it's waterfront property. They did do everything they had to do with respect to the state. They now come to the town. The town says, well, we're hamstrung because that's what the LWRP says. I don't doubt it, but still we just don't want any confusion because we are going to apply to the town board. Hopefully they'll listen to us and we can get this extended, whether it's by amendment to the LWRP or some other method.
Frank, comments?
Mr. Tramarko, I have a question on the resolution. After number 3, it mentions that the applicant was requesting the waiver in order to construct a 4-foot by 70-foot elevated walkway. So I think it was the applicant that requested 4 feet by 70 feet.
That may be so. I didn't handle it. Hopefully I
You didn't
would
look
have
at
phrased
these-
it differently,
look at the
but,
drawing?
you know, it is what it is. He probably did.
Over there.
With the help of the planning department. They've been cooperative.
Let Frank comment first. Frank, you submitted a drawing now, and the cross view that I have of a drawing that was approved by the DEC is a little different than what it shows on the, or what's included there in the recommendation.
That's correct. Okay, let's go back. The DEC issued a permit for a dock. That's what we're talking about here. Docks are not permitted in that area pursuant to the local waterfront revitalization program. The New York State DEC is aware of this restriction, and they issue their permits, and on their permits they say subject to local approval. They do not check the LWRPs. Within this particular regard, they leave it up to the municipality. So permits are issued, and in this particular case to the applicant, but the laws that we are bound by, which are, by the way, the same laws the state is bound by, do not permit a dock in this particular area. In order to permit docks pursuant to the LWRP, we would have to modify the local waterfront revitalization plan. And I am not against modifying that plan. There are several things that were in that plan that were adopted in the 1980s that should be revisited at this particular point in time. However, that said, it is very clear in the LWRP where it states no piers are permitted in this particular area, period. So it is not a discretionary matter. It is not even up to the town board to review, reconsider this. This area is jointly reviewed by the state of New York and the town, as well as the village. So piers are prohibited here. What we have done, and our approach to this, was I felt that we should at least work with the applicant in giving them as much as we possibly can. And that's the way this is written. Not that, if the applicant or somebody wishes to modify the LWRP, or the town board decides that, by the way, and that's a 9-month to a 1.5-year process to modify the LWRP. And I would probably support it. But outside of that, there's no way we could permit a pier in this area. That said, also too, this board is bound by the LWRP. And before this matter was brought before this board, the town board adopted an LWRP which approved this specific project that you have by you. And I have the documentation here. And it does address a 4-foot by 70-foot pier. So the only thing that was approved by the LWRP is that 4-foot by 70-foot pier. If there wish to be changes to be made, we have to go back for a new LWRP, even if it was 71 feet, to get it approved. So that's where we stand at this particular point. There are, I do believe we should modify the LWRP, but that is an effort that has to be undertaken legally, and we have not done that. There is no variance of this particular process.
All right, so that, what we have here is the section that I'm looking at.
No.
The 4 by 70 foot section would not include where they're trying to construct, or they want to construct a pier.
This is what they're doing. This is what we're
Yes.
approving. That's what they wanted.
Yes. I'm
In
sorry.
other words, the 4 by 70 foot section is what we have on our agenda for tonight.
That's correct.
And the part that's out here is something there that was approved by the DEC, but not by the town LWRP, right?
That's correct.
All right, so that what can the client do then? Can it be referred to the town board by our recommendation to consider an amendment to the LWRP?
You can ask the town board to amend the LWRP, yes. And I would support that. I think it would be reasonable. But the town board I don't want to send anybody on a wild goose chase. This has been discussed with board members before. The reason why we haven't done this is because of fiscal constraints. It is relatively expensive to do a modification of the LWRP. The last one that we did, which was in 1994, which was done by Sicardi and Schiff, cost the town about $70,000. And in today's market, I would guess that a new rewrite of this particular issue would cost.
So you understand
Similar.
what I'm saying, Mr. Tramarko? That apparently that the only thing that was approved by the department was a 4 foot by 70 foot walkway out to between the property and the grade that's between the pond and the river. Is that correct?
That's correct.
So now, that's what our action is tonight, with the exception there of referring it to the town board.
I have no objection. I just didn't want your decision to be interpreted as a statement that the dock could not be further extended. So if you pass the resolution and say we also refer this to the town board for a second look at whatever the length of docks, that would be fine. I just don't want it to be interpreted that this board would be against an extension of the dock.
Well, the resolution that we have, and so that would have to change the resolution that we have in order there for the town board to consider that. In other words, we could approve the 4 by 70 foot span between the property line and the ground that's part that comes up out of the water.
Right.
That part we could approve with this resolution, but we cannot approve that without just doing a recommendation to the town board to review the LWRP. But that would have to be something that you would have to have it framed up for us to make a resolution out of it to go to the town board.
I'm sorry, you want me to frame up a resolution?
Well, I think there's got to be discussed with the chairman there.
Mr. Chairman, I would be happy to express, I think, my sentiment to the board, and I think most of the board would concur, that if you could construct docks that are environmentally appropriate in today's world, and they could be improved by environmentalists, my own environmental planner and other people will approve the modern docks, certainly we would support a modification. I've said that publicly, and I've said that to the applicant. I have no problems in conveying that to the town board. The process of how to approve a dock in this area is to modify the LWRP. And quite frankly, that is, even though it's a policy issue, in today's world, it's a fiscal issue because of the efforts that are involved. We're doing the budget right now. I'll be happy to ask the town board, but realistically, this is put on the agenda with other pressing needs of the town. Maybe they'll do this one and not others. I don't know, but I'll be happy to convey that to the town board. This is not the only change I would like with the LWRP. There are other things that are relevant as well. The LWRP was done in the 1980s, and things have changed since that time. So I'll be happy to convey that to the town board. And I've said this publicly on the record, so Mr. Tramarko, you could use my statement as whatever at will. But
That's fine. If the planning board directs Frank or asks Frank to make a recommendation to the town board, I'll do the same, and maybe we could move forward.
All right, I don't have any problem with that so long there as we do it in the form of either an addition there to the resolution that we've got. Can we just put on there another paragraph? Paragraph number 3?
The planning board hereby requests the planning director contact the town board regarding a revision of the LWRP.
Is that sufficient?
yeah, well, I will gladly do that. I don't know if you want to put it as a separate matter for the board.
Well, I think that if
made a
it's
part of
going to
this
be, if it's
resolution.
got to go to the town board anyhow, it might as well go to the town board with our recommendation.
Well, this doesn't go to the town board.
No, I
This
know
is-
it doesn't.
This, what I would do is if the board directed, I would send a letter under, I would say, yours that the board at this directed a request for the town board, like,
Is that acceptable, Mr. Tramarko?
Yes.
Okay.
and I'll
So
accomplish
what
that.
we'll do is we'll make a motion first to do this part of the agenda, and then we'll make a motion to make a recommendation to the town board for a review of the LWRP for a dock.
Okay,
All right?
sure.
All right. Acceptable?
Yes, sir.
All right. A motion there for the River Estates, a request for a waived condition of approval as read.
In the matter of River Estates, number 919, I move that we adopt the resolution as read in accordance with the recommendation of the planning department.
Second? Second. All those in favor?
Aye.
Aye. Opposed? So ordered. Now, a motion is in order for a recommendation to the town board to review the LWRP in relationship to this application.
Mr. Chairman, I'd like to make a motion to our planning department that they approach the town board into making any type of inquiry into the LWRP as it pertains to this particular application with any further type of dock being built.
Second?
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered.
I will submit it to the boards before I send it to the town board so that you could see that it compiles with what your intent is, and I'll then send it to the town board.
Thank you.
You'll get it
Okay.
this week. Okay?
Thank you.
Thank you.
Okay. Now, is there anybody here to be heard on this application, separate there from the recommendation there that we've done? I should have probably got that in before but I didn't. But just in case there, you still have a chance to do it. All right, next item.
Mr. Chairman, the next item on the agenda under Part 3, Item 13, number 163, Valmont Village. The applicant requests a waiver to amend the original resolution of approval in order to modify the building zone ordinance for Lot Number 10 to be in compliance with the R10 zoning district within the subdivision known as Valmont Village, Section 1, Number 163. The map of Valmont Village, Section 1, was granted conditional final approval by the board on September 30th, 1959. This application was approved for a 51-lot subdivision on a 20.8-acre parcel. Subsequent to the approval, it was determined that a portion of the subdivision was split zone between the A and C residential zoning districts and had not been depicted on the approved map. These two districts are now known as R43, single-family residential, 43,560 square feet, and R10, single-family residential, 10,000 square feet respectively. This matter was brought before the board at the October 21st, 1959 Planning Board meeting, and a resolution to modify the building zone ordinance was adopted stating that the regulations of the building zone ordinance as they apply to lots 11, 12, and 13 be modified so as to permit these three lots be platted and built upon in compliance with the requirements of the C Residence District. Lots 10, 11, 12, and 13 are situated on a cul-de-sac known as Marie Drive, and were the only lots in the subdivision situated partly within the A or R43 district's boundary. The board modified the zoning ordinance for lots 11, 12, and 13 so that the subdivision could be developed uniformly for the C or R10 district. However, lot number 10 was not included in the modification, most likely due to an oversight. The applicant is requesting that the resolution modifying the building zone ordinance for lots 11, 12, and 13 be amended to include lot number 10. The applicant is making this request in order to obtain a building permit to expand their home that would currently require the Board of Zoning Appeals granting variances for setbacks. The Engineering, Highway, and Traffic Safety Departments have no objection to this waiver request. The Planning Department conducted a field inspection for this application and determined that the entire subdivision has been developed in conformity with the C or R10 zoning district requirements. Therefore, the Planning Department has no objection to the applicant's request. The Planning Department recommends the board make this application the subject of an on-site inspection. Mr. Chairman, that is the Planning Department's recommendation for Valmont Village number 163.
Is there anyone here representing the applicant? Would you come to the microphone and give your name and address, please?
Hi, good evening. My name is Donna Bolowski. I live at 20 Marie Court in Comac. I'm just requesting that the property be zoned equally as all the homes in my neighborhood are at this point, so I can do some renovations to my home. To be an R10 as opposed to half R4, I think it's R43 on one half and R10 on the other. The whole property should be, I think should be, resolved and waived to the other lots equally.
Frank,
Okay.
This was an oversight?
Yes,
This
I
was
I
all-
believe it was. I mean, if you look at the map, and the map is,
All right.
if you look at the end of the
Right.
court, you see everybody else
It's 10.
is R10, and that one lot.
Has a piece of 43 in it.
Yeah, and what happens is the home that was originally built falls predominantly in the R10 standard, so no variance was necessary.
Exactly.
Now that the applicant wants to put a small addition, all of a sudden they are faced with very significant variances because there is a big difference between the side yard requirements in 1 acre and in a quarter acre, and that's a significant variance.
Is there a true necessity for an on-site, or would the board have any
Pri-
problem without just granting this?
I have no objections.
Right.
We don't think it's board practice, but if the board wishes to grant it, we have no problem with that.
Why don't we find out first if there's anybody else here to speak on this application? All right, would you come to the mic and give your name, please, and address?
My name is Maya Floyd Bearer, and my address is 18 Marie Court. I'm the home directly next to this home. And my concern is if the zoning would impact our property lines in any way or capacity, or if it would interfere with our property in any way. That's my only concern.
No.
The short answer is no. What basically will happen is the side yards that they are permitted are those that are in your neighborhood, which is basically 12 feet, I believe a total of 24 feet for both side yards. And what happens is that the owner is putting an addition on, but they still have to conform to the same setbacks that you are required to have.
Okay, so it's not going to move our property lines in any way?
None.
Okay, that's my only concern. Thank you.
Was there any, was this an affidavit of posting on this?
I believe so, yes. Did you submit your affidavit of posting? Oh, you have it there, okay,
No, you give it to Mr.
thank you.
Okay, thank you.
Very good, thank you.
All right, the board, any reason that you want to do an on-site under the conditions?
Mr. Chairman, I feel comfortable in voting on this this evening because the planning director has stated that it was an oversight, and looking at the situation of Lot 10, it's not that we're looking for a change of lot lines, it's just that we're looking to bring everything into conformity. So with the permission of the board, if any, I would like to make a motion to approve. I don't really see a necessity for this particular issue going on an on-site.
You want to do an on-site?
No, I think we could vote
You
on.
want to
this.
waive an on-site?
Yes, I'd like to waive it.
Resolution on?
Well, the wording of the resolution, I'm assuming, is it's basically be it resolved that the regulation shall now read, and then we just add the number of their lot onto that
Fine.
regulation. That
Right.
basically will be the
Okay.
formal reading of it. Okay, that's the one that's in your packet, and we'll just add their number onto that.
We're adding 10 onto the
For
other.
10,
That's correct.
okay?
All right,
Okay.
motion?
Mr. Chairman, I'd like to make a motion that we approve Valmont Village number 163 to include lot number 10 in the overall zoning of R10.
Second?
Second.
All those in favor?
Aye.
Opposed?
Thank you very much.
So ordered.
Awesome. Okay, I gotta get that from her. Hopefully she got that down. Okay. Mr. Chairman, the next item on the agenda under Part 3, Item 14, number 1144 Esther Estates. The applicant requests to waive the requirement of installing sidewalks within the subdivision known as Esther Estates, number 1144. The map of Esther Estates was granted conditional final approval by the board on January 12, 2012. This application was approved for a 4-lot subdivision on a 1.992-acre parcel with road frontage on Lake Avenue and an extension of an existing cul-de-sac, Anne Marie Drive, to be known as Esther Drive. At that time, the board approved a performance bond estimate requiring the applicant to install 210 linear feet of sidewalks on the west side of Lake Avenue and 210 linear feet of sidewalks on Esther Drive. The applicant is requesting a waiver of the requirement to install all 420 linear feet of sidewalks. The Engineering, Highway, and Traffic Safety Departments have no objection to the waiver request. The Planning Department conducted a field inspection of all sidewalks in the vicinity of this subdivision and determined that there are no existing sidewalks on the west side of Lake Avenue from Woodlawn Avenue to Middle Country Road, New York State Route 25. However, sidewalks do exist on the east side of the road from Woodlawn Avenue to Roseville Avenue. Additionally, no sidewalks exist on or near the Anne Marie Drive cul-de-sac. The Planning Department does not object to the waiver of sidewalks along Anne Marie Drive. However, because of the high traffic volume on Lake Avenue, we do believe that there should be sidewalks on both sides of the street. Insofar as there are no sidewalks in the immediate vicinity, we would suggest that the board accept a payment in lieu of construction for the 210 feet of sidewalks along Lake Avenue. These funds would be set aside for future construction of all sidewalks in this area. The Planning Department recommends the board make this application the subject of an on-site inspection.
Thank you. Is there anyone here representing the applicant?
Vincent Tremarco, 1038 West Jericho Turnpike, Smithtown, New York. I have to agree with the Planning Department that there should be an on-site because, especially on the interior road, my clients have to decide whether they're going to rip out trees that would be in line or in place where the sidewalks are now. So unless you're comfortable with the planning department's recommendation with respect to the interior part of the road.
Well, they're not objecting, the board isn't objecting there to the waiver of the sidewalks on the Esther Drive. Is that right? Is that the way I read this, Frank? It's just that you
Lake
want
Avenue.
there to,
And Lake.
Just
you
Lake
want there
Avenue.
the sidewalks on Lake Avenue to be either put in or to agree there that they want to contribute there to the funds there for the coverage there for the future.
Yes.
Is that acceptable?
Uh,
If not, we'll have to do an on-site and then come back
It's
to
not
you.
acceptable to the extent that sidewalks on Lake Avenue, as Frank indicated, on the east side, there are sidewalks running up and down Lake Avenue. on the west side where my client's property is, they're not recommending the sidewalks be put in, they're just saying, give us the money.
No.
When clients give money to the town, they never put in the sidewalks, it goes to some sidewalk fund. So either you feel the sidewalks are needed, or you don't. If you don't, then why pay money to the town?
Mr.
Well, then
Chamarko,
we'll
I
have to take
disagree.
we'll have to do an on-site.
Okay.
Yeah,
We'll have to do an on-site there and
Fine.
then get back to you, all right?
yes, that's fine.
Mr. Chairman, I'd like to correct something for the record. Mr. Marco, there is two funds that we have in the town. That we have one called the Sidewalk Fund, which is a general fund. And then we have what we call a payment in lieu of construction. Those monies are earmarked, and they're in the budget for the location that they're specified for. Those funds cannot be used for anything else but for that. So it's not a general fund that these monies are being deposited. So if we accept money, they're going to be that's what we said, is payment in lieu of construction, which means they'll be earmarked in the town budget as a fund. And if the highway department or any other town agency constructs sidewalks in this area, they could use that fund. That's it. They can't be used for anything else.
And that money will be there forever. Anyway, you're going to do an on-site?
Yes,
Thank you.
go ahead. You have something to say? No. All right, let's do a motion for an on-site then.
In the matter of Esther Estates, number 1144, motion to adjourn for an on-site inspection.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered. We thank you.
Mr. Chairman, the next item on the agenda under Part 3, Item 15, number 993, Rolling Meadow. The applicant requests to extend the performance bond for a period of 2 years to end on June 21st, 2014, in order to obtain more time to complete construction and all necessary improvements. The applicant received conditional final approval for this 15-lot subdivision from the Planning Board on April 3rd, 2002. A performance bond estimate in the amount of $397,345 was approved by the board and subsequently signed by the chairman. The applicant submitted the bond monies and all related materials to the town, and the town board accepted a performance bond in July of 2002. Planning board approval for this performance bond expired on June 21st, 2010. The engineering department contacted the applicant by letter dated January 18th, 2012, informing them the bond had expired and that they should contact the planning department to make the appropriate application to the board. The applicant submitted a bond extension application to the planning department on June 19th, at which time the application was distributed to all departments concerned for review. The engineering, highway, and traffic safety departments have no objection to the performance bond extension request and have determined the bond amount is sufficient to cover all remaining improvements. Planning has performed an on-site inspection of the subdivision and determined that all required public improvements have been completed. The following items remain to be addressed by the applicant. 1, dedication of the right-of-way known as Rolling Meadow Lane to the town of Smithtown. 2, provide the engineering department with an as-built survey of the subdivision and a monument certification letter. 3, post a growth and life bond for the street trees. It should also be noted that because the performance bond expired on June 21st of 2010, the applicant is required to request 2 extensions of the bond in order to keep the bond active. The planning department has no objection to the applicant's request. However, planning suggests the board grant the applicant a 1-year extension of the bond. The 1-year extension would give the applicant sufficient time to complete the above referenced items and the performance bond release process. The planning department offers the following resolution for the board's consideration. Be it resolved that the planning board hereby approves a retroactive extension of the performance bond for the subdivision known as Rolling Meadow, number 993, for a period of 2 years from June 21st, 2010 to June 21st, 2012. And be it resolved that the planning board hereby approves a retroactive extension of the performance bond for the subdivision known as Rolling Meadow, number 993, for a period of 1 year from June 21st, 2012 to June 21st, 2013. Mr. Chairman, this is the Planning Department's recommendation for Rolling Meadow, number 993.
Thank you. Anyone here representing the applicant?
Mr. Chairman, members of the board, my name is Vincent Tremarco. I represent the applicant. I think you all know where that subdivision is in Fort Salonga. Was built by Tony Hurtado. And the only thing that I question is the growth and life bond. I mean, those trees that were planted in 2002 or 2003, and they've survived, and the planning department hasn't found any dead trees, so why put us to the cost of another growth and life bond?
It's required by law, okay? And if you wish to request a waiver, then put a waiver request before the board for a waiver of the performance bond request. However, probably the engineering department would not recommend approval of that. But you could request it, Mr. DeMarco.
These are the performance bonds.
No, this is growth and life that we're talking about. The
Well,
growth and
the
life
resolution
for
that
the
we have has
trees.
got nothing to do with the growth in life unless there is included in the performance bond.
No, he has to submit what, no, it's not, but what he's talking about is one of the outstanding issues to complete this process is to submit a growth and life bond. And this board is empowered to waive the growth and life bond, but that's not what the subject of the hearing is.
We've got to put a separate request in for that.
That's correct.
God bless common sense. Boy, oh boy. Okay, I'll have to discuss it with Mr. Hurtado. We'll make a separate application. I guess I'm going to do it now.
Oh, Frank, please. In the request, it says that it's for 2 years, but the reso says.
Yes, because,
Mr. Hurtado says that engineering said they
Yes.
would waive it.
well, that's the,
We're only
But you
going
know
with
what?
2013.
I'll have to make the application. I don't say that Frank is wrong on the application. We just didn't think of it at the time, so.
to answer your question, Carl, I'm sorry, Mr. Tramarko, because there's so limited things to do, they could accomplish easily these items within a year. And we're giving them a year's time rather than 2 years to get off the performance bond. We're trying to close these subdivisions out as quickly as possible.
All right.
So you're saying 1 year for the growth in life?
No, I'm sorry, we were talking two different things while you were talking, Mr. Tramarko. I apologize. What the board was asking was questions related to the fact that your applicant, you requested a 2-year from June,
Right.
and I'm recommending 1 year.
Right, that's fine.
Okay.
Thank you.
Is there anyone here that wants to talk on this application besides the applicant? No. All right, we need a motion first for the retroactive extension from 2010 to 2012. Motion, please.
In the matter of Rolling Meadows, number 993, motion to adopt the resolution as read in accordance with the recommendation of the Planning Department pertaining to the June 1st, 2010 to June 21st, 2012 2-year extension.
Second.
All those in favor? Aye. Opposed? So ordered. And the motion there for the retroactive extension there for the performance bond from 2012 to June 21st, 2013.
In the matter of Rolling Meadows, number 993, motion to approve a retroactive extension for the performance bond for a period of 1 year from June 21st, 2012 to June 21st, 2013.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered.
Thank you.
You're welcome.
Mr. Chairman, the next item on the agenda under Part 3, Item 16, number 1105, AJK Plat. The applicant requests to extend the performance bond for a period of 2 years to end on March 28, 2014, in order to obtain more time to complete all construction and necessary improvements. The applicant received conditional final approval for the six-lot subdivision from the Planning Board on February 7, 2007. A performance bond estimate in the amount of $77,899 was approved by the board and subsequently signed by the chairman. The applicant submitted the bond monies and all related materials to the town, and the town board accepted a letter of credit in lieu of a performance bond on March 28, 2008. Planning Board approval for this performance bond expired on March 28th of this year. The Highway Department contacted the applicant by letter dated June 14th, 2012, informing them the bond had expired and that they should contact the Planning Department to make the appropriate application to the board. The applicant submitted a performance bond extension application on June 28th to the Planning Department, and the application was distributed to all departments concerned for review. The Engineering, Highway, and Traffic Safety Departments have no objection to the performance bond extension request and have determined that the bond amount is sufficient to cover all remaining improvements. Planning has performed an on-site inspection of the subdivision and determined that most of the required public improvements have been completed. Additionally, 2 lots have not been developed, and 1 home is currently under construction. Therefore, the Planning Department has no objection to the applicant's request. The Planning Department offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves a retroactive extension of the performance bond for the subdivision known as AJK Plat Number 1105 for a period of 2 years from March 28, 2012 to March 28, 2014. Mr. Chairman, this is the Planning Department's recommendation for AJK Plat Number 1105.
Is there anyone here representing the applicant? You could give your name and address, please.
Michael Hannes, 410 Motor Parkway, Hop Park, New York, 11788. Hanus.
Okay. You understand there the
Yeah, it sounds
recommendation?
like everything's okay.
Is there anyone else to be
Thank you.
talking on this application? A motion.
Mr. Chairman, I'd like to make a motion in regards to AJK Plat number 1105, that we approve the resolution as read.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered. Anything else? Motion
That's
to adjourn?
Motion to adjourn?
Motion to adjourn.
Second.
All those in favor?
Aye.
Opposed? So ordered.